for that quiz today?
There's a quiz today?
Yes, it's on the board.
I didn't see it.
It's like in the...
Ceasefire, guys, ceasefire. Let's continue our ongoing terror Supreme Court cases. Have any of y'all studied Gideon versus Wainwright? Just as I suspected. What? No creepy slide boys? I blame Miss Thunderbird. Miss Hamilton. Creepy slide boys, please.
Gideon versus Wainwright was a very important Supreme Court case ruled in 1963. In it, the Supreme Court made a unanimous ruling that under the 14th Amendment to the United States Constitution, states are required to provide counsel, that is, lawyers, to represent defendants in criminal cases who cannot afford their own lawyers.
You guys would need a backstory on this.
In some pool room in Florida, a burglary took place in the middle of the night. The thuggy-muggy wannabe broke into the pool room, trashed the place, and stole some money. The next morning, a witness saw Mr. Gideon coming out of the pool room. The witness saw that Gideon had a wine bottle in his hand, plus some money in his pockets. The witness then accused Gideon of breaking into the pool room. Based on this accusation by the witness, Gideon was arrested for his trial in Florida's state court.
Do any of y'all know what the Sixth Amendment is? Y'all pull out y'all's copies of the U.S. Constitution and let's see who gets there first. Miss Vanderberg. Will you read it, please?
Yes. The Sixth Amendment says that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense.
So that means Gideon's right.
No, not all the time.
But the Constitution does grant Gideon the right to have counsel.
Well, Before Gideon versus Wainwright, keep in mind that the Sixth Amendment before Gideon versus Wainwright only applied to the federal courts, not to the state courts. Mr. Gideon was held trial in a state court, as it was a criminal case of robbery. I need a volunteer. Ah, Mr. Nadeem. Thanks for volunteering. What's in the 14th Amendment?
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
Thank you, Mr. Nadeem. However, the 14th Amendment was ratified after the Civil War, and it gave defendants some rights on the state level in some courts. That is why Mr. Gideon thought that the 14th Amendment gave him the right to counsel, as in order to come to an equal standing with the opposition in the case which had an attorney. He also needed an attorney so that there is equal protection of the law.
Gideon was too poor to afford a lawyer of his own to defend him. He wanted a lawyer granted by the government to defend him. At the state court, Gideon tried to tell the judge that since he cannot afford his own law attorney, the 6th and 14th Amendment guarantees him the right to have a counsel, or in other words, a lawyer to defend him in a criminal case.
The U.S. Constitution grants me the right to counsel.
The Florida State Court, however, denied his request.
Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the state of Florida law, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I'm sorry, but I'll have to deny your request to appoint counsel to you.
According to the laws of Florida, the only time someone can be appointed an attorney to represent him or her is when he or she is charged with a capital offense. Mr. Gideon only charged with a robbery, so he could not get a free lawyer to help defend himself. So the trial continued, and Mr. Gideon tried to defend himself.
Mr. Gideon, you are convicted of robbery by a jury. You are therefore sentenced to imprisonment for 5 years.
Mr. Gideon lost his case, and he was unable to defend himself against an experienced lawyer. The jury decided that Mr. Gideon was guilty of robbery. He was then sent to Florida State Prison.
This is not fair. The U.S. Constitution grants me the right to counsel. I had to defend myself without an attorney. That's why I lost. Don't, you can't do this.
Get out of here.
The Florida State Court was unfair to me by not providing me with a lawyer to defend myself. I know what I will do. I will file a petition of habeas corpus to the Supreme Court of Florida State. I claim that my conviction and punishment is unconstitutional because I lacked a defense attorney during my trial. What? But why? This is enough. I'm gonna appeal this straight to the U.S. Supreme Court. The Florida State Court has denied my right to counsel, which is guaranteed to me by the 6th and 14th Amendments to the U.S. Constitution. Therefore, I am appealing to the U.S. Supreme Court in a suit against the Secretary of Florida Department of Corrections, H.G. Cochran. Yes, the Supreme Court has decided to hear my case. Time to go to Washington, D.C. and secure my civil right.
The U.S. Supreme Court then heard Gideon's case.
Mr. Gideon, you had filed suit against the Secretary of Florida Department of Corrections, Mr. Conrad. Mr. Cochran has retired and Mr. Wainwright is the new Secretary of Florida Department of Corrections. Therefore, this court case would be named as Gideon versus Wainwright. We may now hear the argument from Gideon's side. Mr. Fortis?
Thank you, Your Honor. You see, the Sixth Amendment to the United States Constitution states that in all criminal prosecutions, the accused shall enjoy the right to have assistance of counsel for his defense. Also, the 14th Amendment to the United States Constitution states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive of a person of life, liberty, or property without due process of law, nor deny to any person with its jurisdiction of the equal protection of the laws. The Due Process Clause and Equal Protection Clause, in my opinion, do agree the right to counsel to defendants in state courts, because in order to have a fair trial, it is important that both sides of the case have attorneys to defend themselves. In the Supreme Court case Betts v. Brady, which was decided 21 years ago, the Supreme Court ruled that the 6th or the 14th Amendment does not force the state to give the defendant a counsel in a criminal case unless the defendant is mentally ill, illiterate, or under special circumstances. The Supreme Court had decided that it was up to the local court's discretion to whether to appoint a defendant a counsel or not.
So which one of y'all can tell me about the Supreme Court case, Betts v. Brady? Miss Hamilton. Tell me about it. You're all over this like a sumo wrestler.
In Betts v. Brady, the Supreme Court had ruled that the 14th Amendment did enforce some fundamental rights granted by the 6th Amendment to the states, which made sure that a trial was fairly conducted. However, the right of counsel was not one of these fundamental rights made obligatory on the states. It says it right here.
I would like the court to reevaluate its ruling in Betts v. Brady and to overrule it by declaring that the 14th Amendment does extend the right to counsel in the 6th Amendment to state courts.
We may now hear the argument from Wainwright's side. Mr. Jacob.
Thank you, Your Honor. The right of counsel stated in the 6th Amendment does not apply to state courts as it only applies to national courts. Also, according to the laws of the state of Florida, a poor defendant can only be granted a counsel by state if he or she is charged of committing a capital offense, which is punishable by death. Mr. Gideon was only sentenced to 5 years of jail, thus does not deserve a free counsel. I would like the Supreme Court to rule that it should be left up to the state's discretion to decide whether a defendant in a state court case should be granted a free counsel or not. That is because counsel does not affect the fairness of a trial.
The lawyers continue to argue about what the outcome of the case should be.
We've had a good argument today. Thank you all. The 9 justices of the Supreme Court have unanimously ruled in the favor of Gideon in the case of Gideon versus Wainwright. The right of counsel is a fundamental right of the defendants, whether they be state courts or national courts. We have therefore overruled Betts versus Brady. The majority opinion is by Black and joined by Warren, Brennan, Stewart, White, and Goldberg. Also, Justices Clark, Douglas, and Harlan have written concurring opinions about the decision. The majority opinion is that the 6th Amendment guarantees the right to counsel on national level and this guarantee is applied to the state level through the 14th as well. The framers of the Constitution believed for the rights of the defendants to be very important, so the right of counsel should be protected by the national and state courts. The right to counsel is very important for the fairness of a trial. A poor defendant without an attorney finds it hard to reach justice in court. Therefore, to make sure that the trials are fair, the right of counsel should be given to defendants.
As you know, the Supreme Court case did not approve Gideon innocent. It just ruled that Gideon, along with other defendants, have the right to counsel. So Gideon went back to the state court regarding that pool room robbery case, but this time he had a lawyer.
So what were the effects of Gideon versus Wainwright?
Before Gideon versus Wainwright, poor defendants could not defend themselves properly at court without an attorney. After Gideon versus Wainwright, the poor defendants were now able to be judged more fairly at court, since they had the right to get a free attorney at the expense of the government to defend them. This leveled the playing field against the poor defendants' opposition. Well, before Gideon versus Wainwright, the states were given a lot of independence in deciding how trials in criminal proceedings were to be held, unless they become very unfair. Gideon versus Wainwright limited the independence of states in deciding the due process of law. Instead, it placed a set of procedures as guaranteed by the Constitution, set as the right of counsel to the states. Also, before Gideon versus Wainwright, public defenders who are appointed to poor defendants by the expense of the state were very rare. After Gideon versus Wainwright, there was a very large demand for public defenders, and many states started to train public defenders to serve defendants in court cases.
Well, why is this case important to study?
Well, Miss Bunderberg, because it might just come in the AP exam. On a more serious note, this case is important because it helps students understand how our courts, both national and state, have changed over time. Also, it helps show what rights of the accused are protected by the Sixth Amendment and how these rights can be incorporated in the states by the 14th Amendment. Also, this case is related to federalism as it shows how the national government can keep the states in check. In this case, the national government made sure that the civil rights of the defendants or trial were not abridged by the states. It also sheds light on the Due Process Clause and the Equal Protection Clause.
I have another question.
What is it, Miss Hamilton?
What happened to Gideon after the court case?
Do you really care about that old weezer? You know who does? Nobody. Nada.
The jury has decided that Mr. Gideon is innocent. He did not rob the pool room.
Oh, that's so sweet.
Don't get too overjoyed, Miss Hamilton. Soon after he resumed his old life, he died of cancer.